Hello everyone. It is so great to be back after a week-long evacuation from Hurricane Milton. My heart definitely goes out to everyone who sustained damages in that hurricane as well as Helene. It's devastating. We're very fortunate that the office did not sustain much damage, nor did our home, but I know that's not the case for many people. So I encourage everyone to look into efforts for relief and help in their areas and help out however possible. So I wanted to jump on here and reply to a comment since I haven't done that in about a week. And the comment is, when someone in Florida passes away and leaves their cash assets along with other CDs, savings, retirement to an adult child in California, what's the best way? No debts. So the comment's a little confusing to me as far as what's meant by what's the best way. I can assume from the comment that the person already passed away. If they had things like savings account, retirement, and CDs that were either not in a trust, owned by a trust that listed beneficiaries, or if these accounts themselves, alternatively, didn't list or name beneficiaries, then these are assets that would be subject to probate. If the person was a Florida resident, then these are assets that would go through probate in Florida. There's no way around that unless, again, these assets were actually owned by a trust or listed the trust as a beneficiary or listed individuals as beneficiaries, which is often the case for at least retirement accounts. They typically almost always have one or more individual beneficiaries or list a trust as a beneficiary. Oftentimes people do also do this with CDs and savings, although I would say it's probably less frequent overall. If they had beneficiaries, good news, whether it's a trust or whether it's a person, you just have to contact the institution that's holding these assets, explain that the person passed away. They will require a death certificate to show that the person actually passed away. And then there's typically maybe something you have to fill out and prove who you are if you're the beneficiary. But the assets in a CD or savings account or retirement, again, as long as you're the listed beneficiary, will go to you directly outside the probate process. If the trust is listed as a beneficiary, these assets would go directly into the trust outside of the probate process. Or if something like the CD or the savings account was actually owned by the trust, well, then you can just skip this whole thing because the trust is already controlling those assets, meaning, again, they do not have to go through probate because they are owned by the trust itself. Now, there are different steps for different banks, but essentially it's a very quick and easy process typically to get assets handed down to a beneficiary, again, as long as the beneficiary is actually named on the asset. And how it works with beneficiary designations is the beneficiary actually owns the asset 100% at the time of the person's passing. They have no ownership rights in the asset while the person is alive, meaning it's not like a joint account. You don't have any present interest in the asset. You can't just go in and take money out of a checking or savings account or cash in a CD. If you're listed as a beneficiary, you would have to actually be an owner to do things like this. However, since the beneficiary does own the asset 100% at the time of the passing, it actually becomes their asset, which does take it out of creditor claims. So I know in this comment it says no debts, which that's great. But even if there were debts, the beneficiary who inherits the account is typically not going to be liable to pay those debts because this account is now theirs 100%. And all debts would go to the decedent's estate, the original owner's estate. And the only assets that would be used to pay those debts usually are probate assets, or of course, if again there is a trust, the trust will often direct the payment of debts, just like a will do as well. Now there are a couple other things listed in here. Cash assets, I guess that was it. So just the cash assets and these other accounts. So typically people, don't take cash through probate either. If it's just, I guess, in a safe or in a box under the mattress. At least I've never even heard about it, because I'm sure as soon as people find those assets, they probably just take those assets and don't even disclose them to anyone. That I think would be more common, especially if there's no record that that asset was being held anywhere, like if it were in a safety deposit box. However, that being said, there are often other assets like cash or other tangible items or furniture, furnishings that a decedent owns when they pass away. In Florida, if they are living in Florida, there is an exemption of up to $20,000 for household furnishings for probate. So I'll get this question a lot. If a house was left to somebody, do the contents of the house have to go through probate? Well, you get an exemption of $20,000. So the contents in the house that are $20,000 or less, which is typically what they are normally, I would say a lot of times less, or a lot of times people I don't think are being very particular on trying to calculate it, unless maybe there is disagreements among the beneficiaries. What I mean by that is normally whoever gets the house is just going to take over the contents of the house. If there is a dispute regarding the house or its contents, then we do normally get into listing out and inventorying what is actually in the house. We have to appraise it, determine what its value is, and take these individual items through probate, although $20,000 worth of the furnishings would be exempt from probate, along with up to 2 vehicles that are exempt, and college tuition plans are also exempt, which is, I think, a newer thing that some people don't know about. But the college tuition plans, the creditors can't get to those through probate, as well as the homestead property, which we do take it through probate to retitle it. But when I say exempt, anything that I'm saying is exempt, it's exempt because creditors cannot make claims against these assets. Vehicles sometimes also have to go through probate, especially if there's loans associated with the vehicles, but up to 2 are exempt from the claims of creditors. So the household furnishings up to $20,000, the homestead, the college tuition plan, the 2 vehicles, none of those are going to be subject to creditor claims. And if you found cash, good for you. I hope it was a lot, and I hope you put it to good use. So I hope this answers this question. If you have any other questions about assets, the labeling of assets, listing beneficiaries, trust, probate, protection of assets, and you're in Florida, please don't hesitate to reach out to our office. We're atCAUSE Law Office, the non-stuffy attorneys, and the link is in my bio.